Hello, my name is Karen Mills and I am the managing member of the boutique law firm Mills Law LLC, which is based in Atlanta, Georgia, and we specialize in corporate transactional, contracts, business law, and mediation. I like to say we do everything from helping you form the entity to selling the entity and a lot in between. And a lot in between is usually contract review, negotiation, and drafting. Now, I've been practicing law for over 20 years, and I've really been in the business field for over 25 years when I started as an electrical engineer, and I also became a registered professional engineer, and then thereafter I started my legal journey. Now, within the last few years of my legal practice, I've noticed an increased need to be able to provide informational resources to entrepreneurs and business owners in the legal arena. I've decided to take a leap of faith and provide some informational resources for these business owners by creating a series called Legal Basics for Business Owners and Entrepreneurs with 3 objectives in mind. And these objectives I call the 3 E's. The first E is to engage you. I want to make sure that you are properly engaged with these resources and that you want to know and understand this information. The next E is to educate you. I know sometimes we are hesitant to say about those things that we don't know, especially in a room of people. So these webinars will give you a safe place to be able to obtain and gain this information. And then finally, I want to empower you because I want you to be able to use this information, or if you can't use it, at least you can give it to somebody else and empower them to use it as well. So remember those 3 E's of educate, engage, and empower. Now, this is our inaugural webinar. It's the top 5 legal pitfalls for business owners and entrepreneurs. You know, I'm an attorney, so we have to have disclaimers. Now, there are numerous legal considerations when dealing with entrepreneurs and small business, but these are just my top 5. Again, there are numerous ones out there. Now, also, keep in mind that this presentation and the information contained herein are not meant to provide legal opinions, offer advice, or serve as a substitute for advice by the legal professionals engaged by you. So in other words, hire you an attorney. Let's start with our first legal pitfall, and that's the failure to engage legal counsel. Now, why do we fail to engage legal counsel? And typically it's for a few reasons. First of all, it may be because we're impatient. We want to get the deal done right then and there, and we do not want to rely and have to take time to go to an attorney. But what I say to that is, do you want to have unhappy clients and customers? Do you want to have a bunch of returns and exchanges? Or better yet, do you want a bunch of lawsuits? Now, another reason why we fail to engage legal counsel is because we dislike attorneys. And we know, and I've heard all the legal jokes about attorneys, but your attorney should be your trusted advisor. And if you have an attorney that you don't trust, keep searching until you find one, because at the end of the day, you should be able to trust the information and the advice that they are providing to you. And then finally, I think one of the main reasons we fail to engage legal counsel is the cost, okay? But keep in mind that you're going to pay. It's just depending on when you're going to pay. Are you going to pay on the front end, or are you going to pay on the back end? And if you pay on the back end, you typically are dealing with a lawsuit and you have no choice in the cost for the attorney. Some of the advantages of engaging legal counsel is you're saving time by you utilizing that attorney's expertise. Typically, that attorney should have been practicing for so many years in that particular area. So they know the laws, the rules, the regulations, the ins and outs, because they have been engaged by clients who may have some of the same issues that you may be experiencing. So why not leverage their expertise by engaging them? The other thing is you minimize your potential for risk by engaging legal counsel. Again, because you're utilizing their expertise, they're thinking about some of the pitfalls that may be out there to be able to help you avoid. And finally, you get to utilize that attorney's network, which means that you get access to that particular attorney's colleagues. In essence, for instance, with me, I I practice corporate transactional law. However, I have numerous friends and colleagues who practice other areas of law. So if you have an issue that involves litigation, I can refer you to my litigation colleague. If you have an issue regarding real estate, I can refer you to one of my real estate colleagues. So just because I practice corporate transactional law, that doesn't mean I can't refer you to other colleagues when you are in need of assistance, which is a major plus when you engage legal counsel. And the key point that I want you to take away with the pitfall of failing to engage legal counsel is to remember that engaging legal counsel on the front end can help you avoid costly litigation on the back end. And now let's go to the next legal pitfall, which is incomplete corporate records. Now, are you familiar with the corporate minute book? This is an example of a corporate minute book. It contains valuable and important company information or your corporate records. Things such as your articles of organization or your articles of incorporation. It includes your annual registration. It includes, if you're a limited liability company, your operating agreement, or if you're a corporation, it includes your bylaws. It also includes any minutes and consents that you may have approving certain transactions. I also, in my minute book, I also keep my bank records. I keep my federal employee identification number as well. So any valuable corporate information you should keep in that corporate minute book. What I often find is that entrepreneurs and business owners typically will file certain documentation themselves. For instance, the articles of organization or incorporation, but then they usually stop and they don't complete the remaining corporate records, which are very important. Now, the advantages of these corporate records are it demonstrates professionalism and good stewardship, because that shows that you have been a prudent business person and you are keeping up with all of those corporate records. It's maintenance. It saves time so that you won't have to recreate the wheel if you ever have to produce all of the contents of the corporate minute book. And it also evidences approval of certain corporate transactions. For instance, if you decided to purchase real estate, and you also want to make sure that you have the proper approval documentation in the minute book that evidences that. It also evidences ownership, as well as it provides information. For instance, if you want to be certified as maybe a minority-owned business, a woman-owned business, or you want to be certified as a disadvantaged business enterprise with your particular state's governing authority, you may use some of that documentation that is found in the corporate minute book as part of your application. So it's very important documentation that you should make sure that you keep record of. A real-world example of how failing to have complete corporate records can actually create chaos for you. I had a client who he and his business partner were the two members of a limited liability company based here in Georgia, and they were so excited of forming years ago. What they failed to do is to enter into an operating agreement, which basically sets forth how the company is going to operate. And what happened is later on, some years after the company had been very successful, they started to have disagreements, such that one fired somebody's family member, and that kind of set the tone, and it started a snowball effect. They were extreme. They got to the point where they really weren't even speaking with each other. And at that point, that's when my client came to me. And the first thing I asked was, let me see your corporate records. And he told me at that time that they never had an operating agreement drafted, which, of course, I rolled my eyes back in my head thinking, not a good thing. Well, needless to say, trying to get those two parties to agree how they should go about dissolving their entity, it just didn't work. And so now they are actually in litigation trying to see how this company can end up being amicably dissolved. Now, had they taken time on the front end to have that operating agreement properly drafted so that it will align with the way they were going to operate, and even include how they were going to terminate if they ever disagreed on matters, they likely would not have ended up in litigation, which of course we all know is very costly and time consuming. The key point that I want you to take away with respect to the legal pitfall of incomplete corporate records is to remember that the corporate records of the corporate minute book is needed for very important transactions such as seeking certifications and bank financing. Now, Let's go to the third legal pitfall, which is failure to have written agreements. Now, why I don't understand that we will not have written agreements in place for various transactions that we take part in. For instance, some of the excuses I hear that the purchase is too small. But what you need to remember is that the size of that purchase may not equate to the size of the risk involved. So it's a small purchase, but it may not be a small risk. The other excuse that I get is that we have such a trusted relationship. We just operate on handshakes. It's too impolite for me to ask for them to enter into a written agreement, which I think is absolutely absurd. Another excuse I get is that the relationship is fluid. And my response to that is wait until it's solid to proceed forward. And then I also get the I gotta have it now syndrome. Well, my thing about that is you need to make sure things are done right. And so that means that you may need to take time to have things properly reviewed before you proceed forward. And that may include having a written agreement in place. Some of the advantages of having a written agreement in place: first of all, it confirms the integrity of the parties. I always say anybody that has integrity never has a problem of putting what they say and what they mean in writing. So when you find someone not willing to put something in writing, that ought to be a red flag to you that this may not be somebody I want to enter into a transaction with. It also promotes consistency of your services and products because you're thinking, you know what, I had something very similar to this. If I can pull up that written agreement that I had for this particular client, it may work for this one by just changing a few of the terms and conditions of it. It also helps other teammates when you have written agreements in place, because while you and the opposing party know all the terms and conditions, the people who actually may have to execute and operate those particular terms and conditions, they need to be familiar with it as well. And why not have something in writing for them to use as a reference and as a guide? And then finally, I think it really memorializes and stops agreement amnesia. I don't know about you, but I review so many agreements on a daily basis, I can't remember from one to the next. So when I have a client that calls me up and immediately starts talking about their particular contract, I usually have to put them, tell them to pause and let me pull that agreement up so that I can have all of the accurate terms and conditions and we can properly discuss things. So what I want you to remember, and the key point about failure to have written agreements, is that creating written agreements, you should do them on the front end. I say do it when you are in the dating phase, because that's when everybody is happy, they have dollar signs in their eyes, and they're typically more willing to agree to particular terms and conditions when everybody is all happy and ready to proceed with the new business venture. Now, let's discuss legal pitfall 4, which is failure to enter into teaming arrangements. Now, when I say teaming arrangements, I'm talking about where we have two parties that may come together to form a partnership or a joint venture so they can act as a prime contractor, or I have a prime contractor that may engage with a subcontractor, or I have a subcontractor that engages with a subcontractor. So that's what I mean by teaming arrangements. Now, why do we often fail to enter into a teaming arrangement? One reason is because we often want to go it alone. We feel that we have this Lone Ranger syndrome where we can get everything done by ourselves. And typically we can't do that. So that's one of the reasons why we fail to enter into a teaming arrangement. Sometimes we may not trust a particular individual because we might have had a previous negative teaming experience. We also fear that there may be an imbalance in bargaining power, that we may be at such a small level that nobody will want to team with us at a larger level. But we should not discount our particular expertise and products and services that we bring to the table. Now, some of the advantages of teaming is that we basically come together to complement each other's services, their products, our expertise. And one thing that you have, this other entity may not have, but it may be of a big benefit to them, so that you all can partner together to go after a particular contract. Because at the end of the day, what you're trying to look for is the best combination of your products, the performance, the cost, and the delivery of services so that you can end up winning a contract. My key point that I want you to take away with respect to failure to enter into teaming arrangements is to remember that it's better to have a small piece of a big pie than 100% of zero. And the fifth and final legal pitfall is the failure to understand key contract terms. And why is it that we fail to understand key contract terms? One of those is because we don't have time. We have so many other things to do with our day-to-day operations of business that we don't have time to properly review the contract. The other reason is we typically will do a cursory review of certain contract terms. Typically, we're going to look for the price and we look for the term. Yet there are so many other terms and conditions that are important to the contract, so we need to review it in its entirety. And finally, we are typically intimidated by the length and the complexity of a contract. So we just say we won't review it at all, which really doesn't make any sense. What we have to do is remember every word counts in a contract. Some of the advantages of understanding key contract terms is that when you review a contract, it will allow you to be able to ask clarifying questions before you sign that particular contract. That means if you don't understand a term, ask. See if you can get clarification so that you will feel comfortable about that term before you ever sign that contract. It will also allow you to identify some key risks that may be involved with that particular transaction. Who knows, you might be responsible for some large indemnification claims. You may be on the hook for some liquidated damages. These are things that you want to know all about before you enter into that contract. It will also allow you to calendar key due dates as well as other important requirements. And then at the end of the day, it's going to allow you to be familiar with what you're signing. It amazes me oftentimes when I have clients who come to me after the fact, after they've signed the contract, and they didn't know what they were signing. I don't want you or any other client or potential client to sign something without understanding those key contract terms. One example of key contract terms that I want to make sure you understand is term and termination. Now, we're often familiar with term. It's typically how long the contract will last. And with termination, it talks about when you're going to end the contract. But oftentimes I've seen where someone will read the term and they go around and they'll brag, I have a 3-year contract with this Fortune 500 company, but yet they never take time to review the termination provision of the contract, where in the termination provision, it may actually give the particular party a right to terminate for any reason upon 30 days notice. So with that being the case, you really don't have a 3-year contract. You really have a 30-day contract with that party if you've given them the right to terminate upon 30 days notice. So you have to review term along with termination. Again, remember, every word counts in a contract. Now, this concludes our inaugural webinar for the series Legal Basics for Business Owners and Entrepreneurs. Thank you for taking time to watch. Now, we hope that you were sufficiently engaged, educated, and empowered. Now, we've recorded and we plan to record additional webinars to provide you informational resources to provide you with a solid legal foundation. Now, we plan to do this at cost-effective prices because we are small business owners and entrepreneurs, so we do understand economic challenges. Now, remember, who better to invest in than yourself and your business? Now, one great way to do that is to invest in informational resources. Please feel free to visit our website, www.millslawllc.com, or contact us via email at info@millslawllc.com, or you can contact us by phone at 770-933-6275. Now, until next time, keep investing in yourself and your business.